Okay, let's go ahead and get started. Can you hear me? Can you hear me back there? Okay, I guess I do really need to speak directly into this microphone. So if I start fading away, just Dan, raise your hand and just or throw something at me back there. It's good. I'm Paul Virtue. I work in Mayor Brown's Washington, D.C. office. I'm a partner in the global mobility practice. And it's a pleasure to be here speaking to all of you today. I have been doing this for about 35 years, this immigration thing. I joined the Justice Department in 1983 during the early years of the Reagan administration. And I have to say, in the 35 intervening years, I've never seen immigration be quite as political a hot potato as it is today. So we'll talk about that a little bit. I apologize if it seems political, but a lot of decision making, well, you'll see. In terms of, oh, that's me, wow. In terms of our agenda, we'll talk about the challenges for offshore staffing vendors, some of the historical views on H-1B status. As we'll see, the past is not prologue in the H-1B world. Let me just ask, how many people in the room have H-1B visa holders or some work visa holders working on site at your facilities, one or more of your facilities? About half the room at least. I'm not surprised by that. We'll talk about the risks for customers. So the people who raise their hand, by and large, are probably the end user or the customer of offshore staffing vendors. And then what suppliers can do to address the issues that we're seeing in the H-1B world. Can anybody tell me what's wrong with this slide? It's still a mistake up there. January 23rd. The inaugural has always been on January 20th every year. So January 23rd, I think we put that up there just to make sure you were paying attention. Or somebody put that up there to make sure I was paying attention, I guess. Exactly. So you'll see and this is part of the president's speech. If from this moment on, it's going to be America first. Every decision on trade, taxes, on immigration, prominently mentioned, on foreign affairs will be made to benefit American workers and American families. We must protect our borders from the ravages of other countries making our products, stealing our companies, and destroying our jobs. So with that sort of mission statement, if you will, from the administration, we started this new era of, especially in H-1B, but also in some of the other visa categories. And as we've seen, approaches to the southern border primarily as well in terms of concern about people coming into the country. In just this last February, the United States Citizenship and Immigration Services changed its mission statement. And the mission statement had read, USCIS, which is U.S. Citizenship and Immigration Services, secures America's promise as a nation of immigrants by providing accurate and useful information to our customers, granting immigration and citizenship benefits, promoting an awareness and understanding of citizenship, and ensuring the integrity of our immigration system. That was changed to remove the reference to let me make sure I can find it here. To remove the reference to a nation of immigrants to say that U.S. Citizenship and Immigration Services administers the nation's lawful immigration system, safeguarding its integrity and promise by efficiently and fairly adjudicating requests for immigration benefits while protecting Americans, securing the homeland, and honoring our values. So we took Nation of Immigrants right out of the mission statement of U.S. Citizenship and Immigration Services. bear with me, my notes page is not moving so quickly. What are the challenges for offshore staffing vendors? There is no industry sector under higher scrutiny from the immigration agencies than IT suppliers, IT vendors. You'll notice the reference to Disney, Southern California Edison, and New York Life. Those companies came under scrutiny in 2014, 2015 for having laid off U.S. workers and replacing them with H-1B workers. At least that was the perspective of the people who were laid off. And actually, there was a lawsuit that was filed against Disney and against the staffing contractor HCL by U.S. citizens who were laid off and, in their view, were replaced by H-1B workers. It was filed as a class action. There was a motion for class certification. Ultimately, it was based on a Title VII discrimination claim by American-born plaintiffs, and ultimately was dismissed without prejudice by the Middle District of Florida because of the court taking into consideration and assuming that the factual allegations were true, nonetheless dismissed the lawsuit because it failed to state a claim upon which relief could be granted for these individuals who were laid off by Disney. Southern California Edison and New York Life had some of the same charges leveled against them, but didn't end up in litigation. The annual, this is just a fact in terms of IT suppliers, the annual H-1B lottery, and for those of you who don't know, Congress provided some 65,000 on an annual basis H-1B visa numbers that are available, and routinely, at least for the last 6 years, the agency receives 2 and 3 times the number of petitions than they have visa numbers available for. So they end up having a lottery to distribute those visa numbers. There's an additional 20,000 for master's degree holders from U.S. universities. So what they do is they have a lottery for the 20,000 first, and then anybody not selected in any master's degree holders not selected in that lottery are put in the main lottery, and they select out a number of visas that will bring them up to 65 plus 20,000, so 85,000 total. This annual H-1B lottery is dominated by Indian IT companies. And then we'll talk a little bit about an issue that is not brand new, but it's becoming more and more prevalent, and that is fraud and forgery of company documents. And when we're talking about company documents, we're talking about documents, letters of support for H-1B visa petitions that are on maybe your company's letterhead as an end user, that are typically counterfeited by an individual, a visa applicant, who maybe has an H-1B petition available to them, but not for a company that's actually doing work in the U.S. And so they find a company that has suppliers on site, like more than half of this room, and they use your letterhead to draft up a letter, and then the State Department comes knocking at your door. This is a quote from Senator Chuck Grassley from Iowa. Senator Grassley chairs the all-important Judiciary Committee in the Senate. He's had the H-1B program in his crosshairs for a number of years, even before the current administration. And legislative efforts to place significant restrictions on what he perceives as misuses of the program have failed to gain traction. But now 2 of his former staffers are in critical positions with the current Trump administration. The USCIS director used to work for Charles Grassley, and the head of the policy shop at USCIS as well. And the result of that has been regulating by policy memorandum. Typically, the Administrative Procedures Act requires that an agency publish changes in their policy for notice and comment under the Administrative Procedures Act. That simply doesn't happen in the current administration, and so we see a lot of publication of memos that that I'll talk about in a moment. H-1Bs are tied into reductions in force, on-the-job training, which is what in the Disney situation, the plaintiffs were alleging that the H-1B workers were taking their jobs and that the individuals who were being laid off had to actually train the H-1B workers to do their work. The perception by Grassley is that these are low-skilled, low-wage positions, and that oftentimes the jobs go overseas so that the H-1B worker comes in, gains the knowledge, and takes the jobs overseas. When in actuality, a number of studies have shown that the presence of H-1B workers actually increase the number of jobs for U.S. workers. Just recently, U.S. Citizenship and Immigration Services published a memorandum. As I said, they're doing policy making by memorandum, requiring additional information be included in petitions to meet the burden of proof, which is a preponderance of the evidence that the individual or that the occupation is a specialty occupation. A specialty occupation is one that would normally require the attainment of a bachelor's or a higher degree in a particular specialty. That there is an employer-employee relationship between the individual and the petitioning company, which oftentimes gets blurred in the staffing situation where resources are being assigned to the end user facilities that many of you mentioned. You have H-1B workers working in your facilities. And that the term of the H-1B that's being requested, which is typically 3 years, that there's sufficient specialty occupation work to cover that period of time. And the other aspect is that the USCIS is requiring additional proof to meet these requirements. Well, what they also did was there had been a policy in effect that deference was being given if an individual had already been approved for an H-1B visa for the particular position in which they're the subject of a renewal. The agency has done away with that deference, and so each petition is considered now on its own merits. So what the agency has done in February of 2018 is now they're requiring copies of the contracts, and if more than one site is involved, an itinerary to show where the person will be working and what they'll be performing. So they've mentioned actual contracts, work orders, and itineraries, and they're issuing requests for further evidence. They issued this policy memorandum just about a week before, or about a month before the annual H-1B cap drive, which starts on April 2nd. And so there wasn't really time to beef up the petitions that had already been in place or being prepared in order to file them. So now we're seeing a lot of requests for further evidence asking for this kind of information. Very important, proof of control over the employee. If the USCIS is not convinced that the actual petitioning employer is the employer, then they're going to deny the petition. So if they feel that as end users, you have responsibility for assigning work and the reporting of the individual on their performance, then they'll deny the petition because there's not an employer-employee relationship between the petitioning company and the employee. How do they gauge that? USCIS Fraud Detection and National Security Agency actually conducts on-site visits with no notice. They just show up at the work site and asked to speak with the individual and the individual's supervisor. And then this issue about the direct relevancy of the university degree is something that has been relatively recent. The USCIS is typically referencing the Occupational Outlook Handbook, which is a publication by the U.S. Department of Labor that gives a sense of what's out there and what's available for someone with a particular background. And they're actually using that to adjudicate whether an occupation is a specialty occupation. So if we took the example of a financial analyst, many of you are from financial organizations here, you're probably not going to limit your search for individuals to serve as financial analysts to somebody who has a finance degree. I mean, because quantitative analysis is part of that job, you'll probably accept somebody with a statistics background or a mathematics background or even an engineering background to fill a financial analyst position. And the agency is now saying that if there are a number of different, if the position could be filled by someone with a number of different academic backgrounds, that it can't possibly be a specialty occupation. We're having to deal with that aspect. And what we've been doing is pointing out that the common thread among mathematics and statistics and finance and some of the other disciplines is quantitative analysis. And we go through and talk about university studies and that kind of approach. The problem with forgery and fraud that we talked about, first of all, you have a limited quota, new and rigorous requirements for proving specialty occupation and employer-employee relationship, and it's creating an incentive for forgery. And in this administration, immigration fraud could make the career of an ambitious assistant U.S. attorney. In fact, in prior administrations, I've known a number of assistant U.S. attorneys whose careers have been made on the back of immigration fraud. So that's not particularly new, but it's something that's becoming more and more prevalent, and it's something that you have to watch out for because, let me just give an example. The U.S. consulate, for example, in India refers questionable supporting documentation to their Kentucky Service Center. The Kentucky Service Center of State Department handles inquiries to the ultimate end user. State Department emails the customer and they ask a series of questions, which are common to most of these, about the legitimacy of the documents that were presented to the consulate and whether the company has a relationship with this particular vendor. Oftentimes, the fraud is being conducted by the employee of a subcontractor, and the ultimate company, the end user company, might not even know about that subcontractor, so that's something to be aware of. The customer reviews the documents, doesn't recognize the signature, thinks it must have been a counterfeit letter. And the answer that they get back from the supplier is, well, we thought it was easier to alter your letterhead so we could get you the staff right away. That's a prime example of what we've actually seen in practice, the response from the vendor. So the company fires the vendor, they give a response to the government, and then they're left with having to replace that vendor, replace those resources, perhaps have a new company hire those resources. Similar situation, but I was helping out one of our prior vendors because my cousin ran the company and needed my help, but don't worry, he won't be using this vendor. That's the explanation. Well, again, the company has to fire the vendor because they've failed to comply with either the master services agreement or the statement of work or some provision in there. So again, you're stuck with How did we get the CLE credit already? Oh, there we go. Okay, we're right in the middle of it. Okay. The CLE number for this session is 05MB89. That's 05MB89. Yeah, they tricked me by putting it right in the middle. What is the risk for the customers, which are many of the people in this room? Joint employment is one where the need to demonstrate, the need to distinguish between an employer and employee relationship and the vendor is often, and the end customer is often a very difficult thing to do because you might actually be selecting the vendor's resources that are being assigned to a particular contract. It's very important to ensure that your master services agreements and in some cases the statements of work make it clear that the vendor is an independent contractor, that they're providing their own tools for the individual to do the work unless there has to be something done on a customer tool, and that the vendor is responsible for assigning work, assessing the performance of the individual, making hiring and firing decisions, paying the salary, paying withholding taxes, and paying the individual the benefits to which they're entitled. Terrorism is another issue here. You do background checks for the people who are on site. You require your contractors to do background checks for individuals who are going to be on site at your facilities. In these forgery situations, if they actually get through and the State Department doesn't identify them, you may end up with a resource you had no idea would be at your facility. As I mentioned in a couple of examples, the end user had to fire the vendor, so staffing continuity is an issue for customers. And then simply the forgery and fraud that you don't know about is costing your company money in terms of transition to new resources and also productivity. And the State Department is prolific about sending out these notices because especially in Chennai, where in India, where many of these applications are coming, are referring a lot of cases over to the Kentucky Service Center. And part of the effect of that is that it's taking much longer for individuals to get their visas abroad because of concerns about fraud and misrepresentation in the process. So what do? You require your vendors to certify that they're in compliance with all federal, state, and local laws and statutes, including immigration requirements, so that you make sure that the vendor is on record as certifying their compliance. That the contractors, as I mentioned earlier, the contracts, as I mentioned earlier, require the supplier to be the actual employer. So they're the ones that assign the work, they're the ones that review performance, they're the ones that handle all the other responsibilities that a normal employer would handle. Subcontractor approval protocols. You want to make sure that your contracts require that if the company with which you have the direct contract relationship is going to engage a subcontractor, that there's a protocol for your approval of that subcontractor. Central leadership over vendor management is very important. You don't want to have a decentralized process for issuing these letters of support for the H-1B petitions. That should come from one central location and one that is auditable. You also want to develop a government response protocol to the State Department, particularly with these questionnaires that come on questionable documents that are being presented at the consulates abroad. And then a staffing continuity plan, which typically you're going to have in your master services agreement. If there's a violation of the master services agreement that the vendor is going to have responsibility for transitioning their resources to a new vendor and bear the cost of that. This is basically the same thing that I've just gone through, just in terms of having a compliance protocol in place and a protocol for responding to government inquiries. I'm going quickly because we're close to the end. STEM graduates, are you familiar? Does anybody have STEM OPT people working for the? Do you know what OPT is? Optional practical training. Okay, students who are here in F1 status are eligible for something called optional practical training for a one-year period after they graduate. The STEM provisions allow for those with STEM degrees to have an additional 2 years of employment authorization beyond their schooling. And what the agency just did within the last few weeks was to say that somebody who's going to be employed in a STEM OPT situation, a student who's going to be employed, may not be assigned to a third-party site. So some of your suppliers, you may have heard squawking about this, but they may have had STEM OPT people working at your site, and now they're not going to be able to. They're going to have to replace those resources. This is a brand new development from USCIS. And we have just a minute or so for questions if folks have any questions. Yes.
What about the L1 program? Are there changes on that side?
You know, there haven't been as many changes on the L1. The changes to L1 actually preceded this administration, so they've actually been pretty tight in terms of third-party placement of L1 employees for some years, and the statute helps from that with that perspective because it actually requires that third-party placement in a third-party placement situation that the company demonstrate that they have on-site supervisors and management of those L1 resources. L1 is an intra-company transfer, so somebody who has worked abroad for the company for at least 1 year in a managerial role or a specialized knowledge position may be transferred to the U.S., and those limitations have been around for a while with L1s. Is that it? Good. I think we're on time. Thanks. Thank you so much.